Welcome to the Cave Law Podcast. Today we are exploring a recent year-end safety review for train riders in Aurora, Colorado.
Right, and it really highlights how just a routine winter commute can, quickly turn into a total physical and legal nightmare for you.
Okay, let's unpack this. Because when temperatures drop, these stations basically turn into this invisible obstacle course.
Oh, absolutely. The safe zones just literally vanish under the weather. And what's fascinating here is that the biggest dangers aren't actually dramatic train crashes.
Oh, wait, really? I think most people assume the trains themselves are the main risk.
Yeah, you would think so, but no. The real threats are these completely preventable routine slips that lead to broken bones and sudden ER visits.
Wow, okay. Like that specific example from the review of the Denver Rider.
Yes, exactly. That one really stood out.
Right, so they step onto a snow-covered platform, poor lighting, and the painted yellow warning line is completely hidden by slush.
Which is terrifying, really.
It is. They slipped, suffered a super painful injury, and missed weeks of work. But it wasn't just the unpredictable weather to blame.
No, I mean, the report points out major systemic failures in Aurora. We're talking delayed de-icing, frozen door mechanisms, and indoor stations with, no consistent heating.
And limited crowd control staff, too, right?
Exactly. When you only have a skeletal crew trying to maintain huge transit spaces, these hazards just sit there.
Okay, I have to push back a little bit here. So what does this all mean? I mean, isn't slipping on ice just a risk of living in Colorado?
That is a very fair point.
Yeah. So why is it automatically the transit agency's fault?
Well, if we connect this to the bigger picture, it all comes down to a legal concept called a common carrier.
Common carrier. Okay, break that down for me.
So public transit systems operate under this specific label. It means they have a legally higher duty of care to you as a passenger compared to, say, a standard grocery store.
Oh, I see. So their standard for keeping things safe is much stricter?
Precisely. Delayed maintenance isn't just an annoyance for commuters. Legally speaking, it's potential negligence because their window to clear that ice is drastically shorter.
Right, which completely changes the dynamic. Here's where it gets really interesting, though. Because if you do fall, you essentially have to treat the station like a melting crime scene.
A melting crime scene. I like that. But yeah, it's so true.
You literally have to pull out your phone and photograph that unsalted ice or that hidden warning line right then and there.
Because if you don't, the evidence literally melts away. This raises an important question about how fast a transit agency's negligence can be erased by just a slight change in weather.
Right. The sun comes out, the ice melts, and boom, your proof is gone before the ambulance even leaves.
Which is exactly why immediate medical attention, telling staff, and taking those photos is so crucial for your case.
It's all about locking down the facts. But stepping back for a second, it makes you wonder about the future.
Oh, definitely. With extreme winter weather events becoming more frequent, transit agencies are going to struggle even more.
Yeah, I mean, if they're already struggling to maintain basic things like working heaters and clear lines, how will the legal definition of reasonable safety have to evolve?
That is the big question. Will courts start demanding fully heated platforms? And how will cities even afford that?
It is definitely something to ponder the next time you are waiting out in the cold. Thanks for dropping into the Cave Law Podcast. Deep insights for complex cases. We're done for today, but the work continues.